Hello, this is Dr. C. This is Module 2's video lecture. Just wanted to touch base with you on what I thought was important when you're reading in that particular section. So let's just get started. And here we go. Legal and ethical issues in education. This is Module 2, it's religion and the public schools. So I think it's important to know that religion was important to the founding fathers. It was the first item that was mentioned in the Bill of Rights. So here's Amendment number 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In fact, before schools became public, oftentimes they were run by parochial schools or parochial institutions, churches. So it's normal for religious topics to be formed or be taught into those schools. So I think it's important that you understand a couple of things. First of all, the 2 clauses of the First Amendment as it relates to religion. First of those clauses is the establishment of religion. So this is called the Establishment Clause. Prohibits government from passing laws that aid a religion or show preference for one religion over another. And if you remember where our founding fathers came from, they came from England, where religion was a huge issue, and practicing one's religion, and the Church of England actually was the only official religion in England. So it became a big issue, and when they came over to the New World and formed their own government, this was one of the most important things. So the first of the 2 clauses in the First Amendment is the establishment of religion. The second of those 2 clauses is the Free Exercise Clause, or prohibiting government from interfering with one's individual religious freedom. And these become a balancing act. The clause, the challenge between government establishing religion and an individual's rights to exercise their religion however they want to. And so these 2 clauses become very critical to what's happening in what you'll have to deal with as a school administrator. So I want to talk to you real quick about these landmark Supreme Court cases that relate to religion. That's been a big issue in our country. As you can see, it started back in 1925, and we'll talk some more about where it's going. So let's look first at this Pierce versus Society of Sisters in 1925. And this was dealing with a constitutional amendment in Oregon that required all their residents to send their children to public schools. That became a religious issue when there were parents in Oregon who felt like that they should have the right to educate their children the way they wanted to. And so the Supreme Court met on this, and stated, as you can see, that the child's parents and their guardians are the ones responsible for making the choice on how they're going to be educated. So the significance of this ruling was that it used the 14th Amendment, the Due Process Clause of the 14th Amendment, to enforce the state's requirement to protect individual rights, and that the parents are responsible for choosing the children or choosing school for the children. Everson versus the Board of Education in 1947. Here's the issue. Can the state provide transportation costs to parents regardless of whether the students are attending private or parochial schools or public schools? And this is a New Jersey case that dealt with the state providing this transportation. The Supreme Court stated that while one part of the Establishment Clause prohibits tax-raised funds from supporting that institution, another part of the amendment can't keep citizens from this free exercise. This is this balance between the state's establishment of religion and an individual's right to practice their religion. And so the Supreme Court said that this payment was permissible, that this was being made to all students, regardless of what their religion was, and they were being made actually to the parents. So the significance of Everson versus the Board of Education, again, applying the Establishment Clause of the First Amendment through the 14th Amendment that applied to the states. But it begins something called the child benefit theory, which states that an act that benefits the child and not an organization is acceptable. And the Supreme Court's going to use this and going to point back to this over and over and over again. So in 1962, Engle versus Vitale. This is the issue. Can a school board create a prayer to be read each day at public schools? Even though this is a case out of New York, and even though the Court of Appeals in New York said that the practice was okay, as long as the schools did not compel any student to join in the prayer, the Supreme Court said that it was a violation of the Establishment Clause of the First Amendment. And so this is going to be the first in a very long list of school prayer cases where the Supreme Court has very consistently held that prayer in schools, school-sponsored prayer in schools, is a violation of the Establishment Clause. And so we will see that over and over and over again. In 1971, the Supreme Court case of Lemon versus Kurtzman, this case came out of Pennsylvania, and it was a case where the state of Pennsylvania was paying part of the salary for the teachers in church-supported schools when those teachers were teaching the secular part of the curriculum. And so the court said that this was disallowed. They overturned this law, and they created something, and this is probably the most famous thing that they did through this case, is they created something that's now called Lemon Test. And in the Lemon Test, it's a three-part determination between a law on whether a law is permitted through the Establishment Clause of the Constitution. And these are the three prongs, if you will. The statute or the law must have a secular legislative purpose. The second thing is that the primary effect of the statute must not be to advance nor inhibit religion. And then the third part is the entanglement prong. It says the statute must not result in an excessive government entanglement with religion. And for the next 40 plus years, the court and appellate courts and state courts use the Lemon Test whenever they are being whenever they find that there are challenges to the First Amendment rights. So the Lemon Test is extremely important, and then you will see it referenced in all the rest of the court decisions, or many of the rest of the court decisions dealing with prayer or religion in schools. In 1972, the Wisconsin versus Yoder case. Can a state use compulsory attendance laws to force kids to attend school? In Wisconsin, they had laws that said that students had to attend school. Fortunately, some of the Amish residents of Wisconsin felt like that violated their religious beliefs. The Amish parents felt like that they themselves were responsible for their children. So the Supreme Court said that these compulsory attendance laws were in fact unconstitutional because they prohibited the students' free exercise of their religion. Again, this balancing act between the Establishment Clause and the Free Exercise Clause. So here's the significance. The court decided that the parents' right to freedom of religion outweighed the state's interest in educating its children. And this case, again, points to the Supreme Court upholding the right of a parent to choose their child's school or their child's education. So another point where the parent has the right versus the state having the right. The Wallace versus Jeffery case in 1985, as you guys probably know, prayer and religion in schools is a very political topic. And so various states have tried to institute different laws or statutes that would kind of get around more recent court decisions. In this case, in 1985, Alabama passed a statute that allowed for a period of silence for meditation or voluntary prayer. Is this a violation of the Constitution? So the Supreme Court said the words voluntary prayer violated the first prong of the Libman test, and therefore it violated the First Amendment. So the significance here is that this court is continuing to define this prohibition against the state-sponsored prayer in schools or government-sponsored prayer in schools. And in this particular case, we talked about last week, we talked about dissenting opinions. In this case, Justice Berger and Rehnquist wrote dissenting opinions, and their ideas in the dissenting opinions are going to be used in subsequent court decisions. 1992 is the Lee versus Weisman case. This case is when a school invited clergy members to give invocations and benedictions at school graduation ceremonies. Again, we're trying to define this difference, or this, we use the term separation between court and state, state and religion. So that's really what's being defined. Court said that all three prongs of the Lemon test have been violated. You see those reasons why. And so basically disallowed adults, clergymen specifically, but adults generally, at giving invocations and benedictions at school graduation ceremonies. And in the Lee versus Weisman case, they introduced the coercion test. And basically that's a test where people are coerced to support or participate in religion or its exercise. And the state cannot coerce other people to participate in a religion or a religious exercise. In the Santa Fe Independent School District versus Doe in 2000, this is actually came out of Texas, and I actually was a principal, high school principal, when this case was decided. Oh, excuse me. So we watched it as it went through the circuit court path and all the way up to the Supreme Court. The question here is, may a student say a prayer before a school-sponsored event? In this case, it was a football game. And so the Supreme Court's now, they've already said that the clergy, an adult, can't do it. So the next question becomes, can a student do it? The Supreme Court has been very consistent in saying a school-sponsored prayer before any school-sponsored event is a violation of the Establishment Clause of the First Amendment. Anytime that the school, as a as a governmental entity, is involved in creating these opportunities, then the Supreme Court's been pretty consistent in saying that that is a violation of the First Amendment. So here's what else they said. They said that the Establishment Clause includes student-led, student-initiated, non-sectarian prayers. Said, and you can see that regardless of the listener's support for or objection to the message, an objective Santa Fe high school student will unquestionably perceive the inevitable pregame prayer is stamped with her school's seal of approval. In other words, by the school allowing this to take place, or creating the opportunity for this student-led prayer to take place, then it kind of gives the message that the school is supporting that particular religion. And that violates the Establishment Clause of the First Amendment. So the state's been very consistent. So this thing should have been I mean, we should have had this handled. This should be all the decisions or all the questions should be answered, but that's not the case. You know, you are going to face, as a school principal, you are going to face issues related to religion in your school. Just look at some of the recent headlines. These all come from Louisiana. September the 17th, the Bossier Parish is wrestling with this question of school prayer or prayer at school graduations. Somebody filed a complaint. The Louisiana Attorney General on September 23rd makes this statement: we will get prayer back in public schools. One of the strongest issues, or most difficult issues as a school principal, is that religion in schools is such a political issue. And there are politicians who make these kind of comments about getting prayer back in public schools. And when you know, they kind of put us on put us in the middle on the hot seat. Just last month, a mom in Webster Parish said that she was suing the school district because they promoted Christianity. It's a long list of allegations that this mom comes up with about the school supporting prayer, the teachers having religious posters in their room, and I mean, just a long list of things. And then even as early as, you know, a couple of weeks ago, the Louisiana Attorney General, I guess he made true on his promise in September, but they issued guidance to the schools that say that students have a right to pray and read the Bible in public schools. In fact, that's part of your reading materials for this week, is that document that the Attorney General has put together. So the point is, guys, is that religion in schools is going to continue to be an issue. And you guys as school principals are going to face it. It's not a matter of if, it's a matter of when. It will come up. So what are some potential scenarios? What do you do when you come up with some scenarios? So I just wanted to throw a couple of scenarios at you, and then we'll draw an end to this particular video lecture. So here, what do you do in this situation where a teacher is assigned students to research a religion of cultures that they've been studying? They may have been studying Christianity or Islam, Judaism, Buddhism, Hinduism, any long list of religions and throughout the culture and world history that they you know, that these students would be studying. So a particular student's parents find out, they call you and want to have a conference with you and with this teacher. And they say that the teacher has no right promoting other religions in school, and they want you to investigate. And if, by the way, you don't do what they want you to do, or you don't take care of this issue, they're going to not just go to the school board, but they're also going to go to the media. We're going to make this a media circus. So what do you do? So here's what I do. First thing I do is I try and reason with the parents. Parents, hey, this is an academic assignment. They are studying various different cultures. We are not trying to inundate your child with any religion, but they're studying various different cultures, and we would like for your child to participate in this project. If the parent is adamant, and if it is apparently a huge issue with them, then I would ask the teacher to reassign the student into a group that was studying a religion that would meet with whatever the parents' guidelines are, or would ask the teacher to create another assignment for this particular student. Ultimately, I believe that it is the parents' right to be able to choose what their children are learning in school. And if it's such an issue, after having tried to reason with them, after having tried to support the teacher, I would try to very diplomatically work with the teacher to find another assignment. So what would you do? So what would you do? You're an elementary school principal where your very best second grade teacher gave an assignment for students to create a poster for something that the student is thankful for. And so this is the poster the child made, picture of Jesus, something that they were thankful for. Then all these posters are being displayed in the hallway. You see it as you're going by, this picture of Jesus as you're walking down the hallway. What do you do? So I think the short answer here is you don't do anything. First of all, nobody said anything. You just happened to see it. And so I would note, hey, there's a picture of Jesus in the hall, but I wouldn't go any further. I mean, there's nothing, it's not violating anything. And in fact, if you were to take that child's poster down, then you would be violating that child's free exercise guarantee on the First Amendment. So let's say that an atheist parent saw the poster and says now that the presence of this poster is upsetting their child. Now what do you do? Now there's an issue. So think about that just a second. What do you do in that particular instance? So here's what I would say. I would talk to these parents who are complaining and talk to them and share them and try to educate them on the First Amendment, on the Establishment Clause and the Free Exercise Clause, and how we are prohibited, as a government, we are prohibited from being able to prevent a child from the free exercise of their religion and the expression of that. And so in this case, that child's expression of their religion is protected by the First Amendment. And so you would have to tell those parents that. Okay? So instead of Jesus, what if the poster looked like this? Again, the topics here are fine, but this is a picture of Muhammad, the prophet of Islam. So what if it looked this way? Chances are, if you live in communities like I have lived in all my life, they are primarily Christian communities and very vocal and passionate about living their Christian beliefs in their life. And this would probably have a whole lot more likelihood of becoming an issue for me in the places where I've worked than a picture of Jesus. But the situation doesn't change. The student still has a protected First Amendment right to practice their religion. And the assignment was secular in purpose. It was, what are you thankful for? The student's poster basically said that they were thankful for Muhammad or for the prophet. And so in this case, that student still has a First Amendment right. And parents who complained would have to be educated to the fact that that child has a First Amendment right to religion, to their religion. It's another scenario. Fellowship of Christian Athletes, a very popular group. They've asked permission to hold their meetings on campus after school, and the school allows other student groups, maybe the Boy Scouts or the Girl Scouts or some other student group, to hold similar types of meetings. What do you do? While we haven't talked about this particular Supreme Court case, it was talked about in your text. I mean, if you allow one group to hold meetings in your school, you have to allow every group to hold meetings in your school. So your FCA group, if they were having meetings in your school and you had a Satanist student group that wanted to hold meetings in your school, you would have to allow them to do that, because you cannot prohibit the free exercise of their religion. So here's some last words, just some last things that I want to leave with you. Understand, government-sponsored prayer is not always unconstitutional. In fact, your textbook talks about this, and it's actually on your quiz, so make sure you listen. The Supreme Court has upheld the fact that prayer can be used to open legislative meetings. So meetings of state legislatures, Congress, every time Congress has an opening, there's a prayer that is read or prayed. Someone comes in and says that. So those have been supported by the government or by the Supreme Court. Also remember that religious texts like the Bible, the Torah, the Koran, any religious text, those can be taught in public schools as historical and literary works. And in fact, in many states, many of the, especially southern states, there are classes actually that are taught. The Bible can be taught. The New Testament and Old Testament of the Bible can be taught. The Torah, the Koran. So just because they're religious doesn't mean that they're prohibited. It just means that we have to be very careful and aware and understand that those have to be looked at as historical and literary works. Understand that you as a school principal cannot prohibit an individual's right to exercise their religion as long as that practice does not disrupt school. So for an example, if a group of students were wanting to have this big prayer meeting that would interfere with classes, then that obviously would be disruptive to school. You can govern that. You can prohibit that. Maybe the biggest thing I need you to understand is that you as a school administrator are always an officer of the government. Despite what your personal religious beliefs might be, despite what your personal political beliefs might be, you are always an officer of the government. I told you that I was a school principal when the Santa Fe versus Doe case was going through the circuit court, Fifth Circuit Court, and then the Supreme Court. And during that time, it was easy for folks in our community, a very Christian community, to say, by golly, we're going to pray and we're going to do this and we're going to do that because we're a Christian community. While personally, I may have agreed with them and did, as an officer of government, I had to prohibit, I had to keep, to do away with this practice of us having a person come up, whether it was a preacher or a youth minister or a student, to come up and say a pregame prayer. In that capacity, there were some folks who I went to church with, folks who were, in my school, who were parents in my school, that just could not believe that this Christian man who was the principal of the school was going to support not having a prayer before these ball games. My personal religious and political beliefs could not interfere with my job. And my job was, I am an officer of the government. And you'll run into those kind of situations. And then also remember that not all the students in your school are going to have the same religious beliefs as you, or even as the majority of your community. And even in these rural and suburban small school districts where I worked, where the majority of the community, the majority of the students were Christian faith, we had some that weren't. We had Muslims, we had students who were Buddhist. I mean, we had students who were from other religious beliefs. So it is my job as school principal to make sure that their religious rights were protected just like those of the Christian students. So that's it for the video lecture this week. I hope you enjoyed it. It'll always be a part of your job as a school principal. So you'll continue to have to deal with these kind of issues. So I just wanted to give you my take on that, and I certainly look forward to our discussion on Wednesday.